Well, PT365 for prelims 2026 of Polity, Governance and Social Issues has been released by Vision IS, and we are starting the discussion of the most awaited document. Okay, so let's start from chapter number first, which is functioning of Parliament, State Legislature, and local government. So, 50 years of national emergency. So NASA emergency has marked 50 years. Okay, in 2025, last year. So there could be a probable question on this topic, national emergency, in this year prelims. So why in news? 2025 marked 50 years since the imposition of NASA emergency declared on June 25, 1975, and lasting until March 21st, 1977. Now let us understand the about emergency. Okay, so you know that whatever current is happening, you need to have the background of that current event. Okay, which means a static portion you must know. Okay, so that is why it is important for us to understand the this one about emergency in India. So source, so suspension of fundamental rights during emergency, borrowed from Weimar Constitution of Germany. Then constitutional basis Article 352 300 to 360 under Part 18 of the Constitution deal with the emergency provisions. Instances national emergency proclaimed three times. Okay, in 1962 Chinese aggression, 1971 on account of Pakistan war, and 1975 internal emergency. Okay, on the pretext of internal disturbances. Now, types of emergency. You have types of emergency. So you know that there are three types of emergency. Article 352 deals with national emergency. Then president rule is there in Article 356, and at the last you have financial emergency under Article 360. Now, the grounds on which these three are declared. So, national emergency on the ground of war or external aggression, a war or external aggression. This is also called as the external emergency. Then you have armed rebellion, that is internal emergency. And if we talk about the ground on which the percent rule is declared, so breakdown of constitutional machinery. So Article 356, failure to comply with union direction, Article 365, and financial emergency when there is a perceived threat to financial stability or credit of India or of any part of territory. Okay, so all these things are there. So Persian rule is important today from the exam perspective. Why? Because recently the Manipur revocation of Persian rule has been done in Manipur. Okay, which was there for the last 3 years. There was a Persian rule. Okay, so Persian rule, please prepare this one and remember this one. Okay, now you have aspect authority, parliamentary approval, duration, when Lok Sabha is dissolved, majority required, revocation, center state relations, tenure of legislation, and fundamental rights. So this is the entire table. Let us understand. Now, talking about the proclamation of national emergency, so it is so national emergency is proclaimed by president after receiving written decision of the union cabinet. Okay, earlier there was no requirement of having written decision of the union cabinet, but 44th Constitution Amendment Act added that the without receiving a written decision of the union cabinet, person cannot proclaim president. Okay, now parliament approval so must be approved by both houses within 1 month. Okay, so parliamentary approval must be approved by both houses within 1 month. Okay, then duration it is valid. So national emergency remains valid for 4 months. Can be extended indefinitely with parliamentary approval every 6 months. So it was again added by 44th Constitutional Amendment Act 1978. Now, when Lok Sabha is dissolved, so continues until 30 days after first sitting of reconstituted Lok Sabha, provided Rajya Sabha has approved it. Okay, so when Lok Sabha is dissolved, then it continues until 30 days after first sitting of the reconstituted Lok Sabha, provided Rajya Sabha has approved it. Majority required. A special majority of total membership, a special majority, which means the majority of total membership and two by third members present and voting. Revocation can be revoked by person at any time without parliamentary approval. Lok Sabha may disapprove continuation by simple majority. Okay. Center-state relations. Center may issue executive direction on any subject. Parliament can legislate on subject list. Person may modify revenue distribution. Tenure of legislature. Lok Sabha and state legislative assembly may be extended 1 year at a time, but need not beyond 6 months after emergency ends. Fundamental rights. Enforcement of fundamental rights may be suspended under Article 356 except Articles 20 and 21. Now, major constitutional amendments and reforms during and after emergency. So this is most important thing. So 39th, you have 13. Just a minute. So you have 39 amendment. 39th amendment. Parliament in power to decide election disputes. 1975. Okay. Before that, 97, there was 38 amendment where judicial review of emergency declaration 1977. Then you have 1976 42nd amendment sweeping changes including primacy to directive principles, curtailment of judicial powers, extended Lok Sabha term. Okay. Then came the year 1977. Shah Commission probe into emergency causes and excesses. So the Shah Commission was appointed, which was responsible for investigating the national emergency abuses and the excesses related to that national emergency imposition. Okay. Then 1978 40 came the 44th Amendment, which replaced internal disturbance with armed rebellion, restored judicial review. Okay. Now, other changes brought through 44th Amendment Act 1978. So, 44th Amendment Act 1978 is basically seen as the reform as the step to restore whatever bad thing were done by 42nd Amendment Act. Okay. For example, for emergency, Union Cabinet to communicate to President in writing. Okay, so President earlier, what President can take any decision. Okay, President alone can promulgate the national emergency. Okay, but 44th Amendment Act 1978 made it compulsory for President to have written permission from the Union Cabinet for imposing the percent rule. Okay, now mandatory parliamentary approval within a month by a special majority. Okay, for emergency proclamation. Restricted scope of Article 359, that is Article 20 and 21, remain enforceable during emergency. Article 358 automatically suspended the rights under Article 19 only for emergency imposed due to war or external aggression. It also omitted right to property as fundamental and made it constitutional right under Article 300A. Removal of Article 257A allowed Government of India to deploy any armed force of Union or any other force to deal with any grave situation of law and order in a state. Now, term of Lok Sabha back to 5 years from 6 years by amending Articles 83 and 172. Restore judicial review to review election dispute concerning president and vice president. Now, ascend to now next topic is ascend to state bills. Why do it is in news? Because Supreme Court in 16 presidential reference under Article 143 held that court cannot impose any timelines for decisions of president and governor on granting assent to bills under Article 200 or 201 of the Constitution. Now, key highlights. So, Supreme Court has reversed earlier its decision, which was granted that the governor or the person must decide on granting assent to bills uh, within 3 months. Okay, so that was decision. Now, court has said under 16 of presidential reference under Article 143 that court cannot impose any timelines for decisions of president and governor on granting assent to bills under Articles 200 or 201 of the Constitution. Now, key highlights of the judgment on 16 presidential reference. So, deemed assent unconstitutional. Uh, Courts cannot assume assent to bill merely because court ordered time lapsed, as it infringes constitutional powers of president or governor, violates separation of powers and federal constitutional scheme. Governors, president cannot sit on bills indefinitely. as it violates federalism, legislatures will, and constitutional morality. Limited judicial review. Courts can intervene if governor or person acts with malafide intent or review is confined to procedure, not merits. Supreme advice not required. Person need not seek Supreme Court's advice whenever governor reserve a bill for his or her assent and subjective satisfaction of person is sufficient. Now, note Constitution of India under Article 163 to explicitly mention that in certain aspects of governor of a state acts in his or her own discretion. However, Constitution does not empower President to independently assume or to take up a call bill unless it has been first been reserved and forwarded by governor. Now, Now there is a constitutional provisions regarding assent to state bills. Okay, so governor's responsibility for a state bill, Article 200 of the Constitution of India. A state legislature passed a bill to governor takes one of the four actions. Okay, either he can grant assent and then bill becomes law, or withhold assent, bill is rejected, written for reconsideration with suggestion for amendment, or he can also reserve the bill for the president consideration. Okay, so that is the thing. Now governors may do this as soon as possible. Okay, then what happens when he returns the bill for reconsideration of the legislature? Then if the legislature passes again with or without changes, then governor must give assent. Okay, now personal responsibility for bills is reserved by governor under Article 201 of the Constitution of India. A governor reserve bill for the president. President takes one of three actions. Either he can give assent, then it bill becomes law. If he does not give assent, then it is rejected. And if he return for reconsider with suggestion for amendment, not money legislature must reconsider and pass within 6 months. Okay, then person either can grant assent or withhold assent. Okay, person makes final decision to give assent to reconsider bill. Okay, now key difference, unlike governor, president is not applied to give assent to reconsider bills. Okay, so person is not bound to give assent to reconsider bills. Now other key highlights of the state of Tamil Nadu versus governor of Tamil Nadu judgment. Aspect in action is unconstitutional. Detail governor or person cannot exercise pocket or absolute veto on bills under Article 200 or 2 and 201. In action can be challenged via writ of mandamus. Writ of mandamus cannot be issued against private individual or body to enforce department instruction, and that does not possess a statutory force when duty is discretionary to enforce contractual obligation against President of India or state governors, against Chief Justice of a High Court acting in a judicial capacity. So, not these are things you can see. Now, Office of Vice President, recently CP Radhakrishnan elected as the 15th Finance Commissioner. Now, election procedure: Vice President nomination requires 20 proposals and 20 seconders. 20,000 deposits is mandatory voting conducted in Parliament House using a special ECI supplied pens. First preference vote is compulsory supervision. ECI appoints the returning officer, Secretary General Raj Sabha, and the observers. Key safeguards followed in election provisions of the anti-defection law are not applicable. Violation of secrecy or use of unauthorized pen invalidates the vote. Bribery or undue influence is ground for election challenge under Presidential Vice Presidential Elections Act 1952. Then year 39. Now constitutional provisions related to Vice President of India. So you know these things are there, not important. Now he is ex officio chairman of the Raj Sabha. Okay. Then election elected by members of an electoral college which consists members of both the houses of parliament, both elected and nominated members. System of proportional representation by means of single transparent and secret ballot. Okay, qualification: citizen of India 35 years and must not hold any office of profit. Qualify for the election of the member of the Raj Sabha. Term 5 years. Resigned by submitting written resignation to President. Removed by Raj Sabha. Passed by a majority of its total membership and approved by Lok Sabha. Continuation of successor resumes charge. Now, a Speaker of Lok Sabha. So, by news, Lok Sabha Speaker has nominated a member MP as an panel member to preside over House proceedings. Okay, so all these things. So, how his removal can happen? Resolution passed by majority for all the then members of the House, provided minimum of 14 days notice has been given. Okay, now not much important things. Now, anti-defection law. This is important because in last 5 years, I think two questions were there from anti-defection law. So let us see the anti-defection law. So anti-defection law provides for disqualification of MPs who voluntarily give up party membership after being elected on party ticket, included under 10th schedule via 52nd Amendment Act 1985, lays down the process by which legislation may be. Now let us see the grounds. Okay, grounds is important. So, disqualification happens when a member voluntarily gives up the party membership for votes or abstain against party whip without condonation within 15 days. An independent member joins any political party after election. Okay, a nominated member joins any political party after 6 months of taking a seat. Except party merger is allowed if supported by two-thirds of legislature. The Speaker of Lok Sabha, Deputy Speaker, Chairman of the Rajya Sabha, and Deputy Chairman of the Rajya Sabha may resign from party and rejoin after demitting office. So these are the exception. Now, judicial pronouncement Kyoto Holland versus July 1992. Speaker decision under anti-defection law is subject to judicial review. Okay, so that is the thing. Now, disqualification of a sitting lawmaker. Also, this Constitution provides Article 102 and 191 specify following conditions into which MP or MLA respectively can be disqualified: holding office, appropriate person of unsound mind, undischarged, insolvent, not a subject of India, defection, or disqualified by or under any law made by Parliament, existing legal and judicial framework to disqualification after crime. So RPA 1951, if imprisonment of 2 years or more. It includes conviction for 2 years or more in crimes like bribery, rape, promotion, enmity, promoting enmity or untouchability, corruption, disloyalty. Lily Thomas was Union of India 2000 Supreme Court ruled that the lawmaker is immediately disqualified from attracting such conviction. Manoj, then another case, appointing minister with no backgrounds are not legally barred, but will him to avoid selecting. Okay. Then 2018 case cannot add new disqualification grounds. The only parliament that political party revoked membership and denied tickets to Kenya with serious criminal cases. Now removal of ministers upon detention. So key grounds for removal: union minister, chief minister, state minister, prime minister to be removed if arrested or detained for 30 consecutive days for an offence punishable with 5 years or more imprisonment. The bills propose significant amendments to Article 75. Okay, procedure for removal: union minister, the except prime minister, president removes the minister on PM's advice by the 31st, otherwise automatic cessation. Except CM, governor removes the CM's on CM's advice. Delhi ministers, president acts on Delhi CM's advice. Okay, prime minister, chief minister must resign by 31st day of custody. Failure leads to automatic removal. Reappointment, no power on reappointment after release from custody. Now, parliamentary committees. Recently, Lok Sabha Speaker stated that parliamentary committees are not. So, about parliamentary committees, so PC is appointed, elected by House or nominated by Speaker, which works under direction of a Speaker. Presents its report to the House or Speaker. PC have the origin in the British Parliament. Now, these is the types of you can see. Now, local bodies not important much. This is also official language. It is important. Uh, Now, official language. So it is a part of also part 617, Article 343. Official language of Union shall be Hindi in Devanagari script. Official language Act 1968 provides for use of English in addition to Hindi for all official purposes of Union business transactions in Parliament. Article 3, Constitutional Commission and Committee on the Inter Parliament, not important. Money bill, yes, important. Financial bill. Article 171 covers matters related to money, which Article 110 can be introduced only in Lok Sabha with President's recommendation. Article 173 bills involving expenditure from conservative fund of required by President's recommendation. After finance bill and money bill, about finance bill and money bill, finance bill can be introduced only in Lok Sabha. Rajya Sabha can only recommend amendments in the bill. It cannot amend or reject the bill. Bill has to be passed by Parliament within 75 days of its introduction. As finance bill is money bill, so no joint sitting or two houses are allowed. So all this is private member bill. So zero are, so few more things are important. So private member bill. So private member bill is basically introduced by a member who is not a minister. Okay, so here is the adjournment. Adjournment signed die. Okay, signed die. So Latin word without assigning a day for further meeting. In parliamentary term, it refers to end of a session of parliament without setting a date to reconvene. Okay, authority presiding officer. Then 0 hour, you have 0 hour period immediately following question hour and laying of papers. Now question hour, first hour of every parliamentary sitting. National Vidhan application, Ministry of Parliamentary Affairs, aim digitalize external legislative process across 37 states UT legislature through a unified platform. So this is the thing. So we have ended the first chapter. We'll start the second chapter after this video lecture. Thank you.